So the drastic advice from the CJ is the culmination of a long journey that has ended in failure at every turn. The two-thirds gender dilemma has stalked 3 parliaments, the 10th, 11th and the current one, the 12th. And in 4 attempts, they have all failed to find a solution. Sam Ogina now reports on the article that was meant to cure gender disparities but has remained good only on paper 10 years later.
It looked good on paper and was widely celebrated by gender activists and those who fought for equality in the country. But the two-thirds gender rule has remained as elusive as it could ever be. In a male-dominated house, the two-thirds gender rule has been reduced to a women's agenda. And for a record 4 times, attempts to enact the gender parity rule has come a cropper. In the 12th Parliament, there are 76 women lawmakers, this falling short by 41 seats to make it 117, or 1/3 of the 349 MPs. In 2019, the vote on the two-thirds gender bill flopped for a 4th time, following a quorum hitch. On voting day, there were only 174 MPs in the House, but as a constitutional amendment bill, it required a supermajority of at least 233 out of the 349 MPs to sail through. The Constitution of Kenya Amendment Bill 2018, sponsored by the then Majority Leader Aden Duale, collapsed without being put to a vote. This is the second time Duale had suffered the same fate. Voting on the Duale bill had been deferred in October of 2018 after only 208 MPs showed up in the chambers for debate. Upon promulgation of the Constitution in 2010, the Supreme Law gave a deadline of August 27, 2015 to enact laws to effect the gender parity rule. But throughout the life of the 10th Parliament that expired in 2012, the 11th Parliament that went all through to 2017 and the current 12th Parliament, the gender agenda has been a slippery slope.
Maraga is standing on the right side of history.
Yes. There is no law and no wish and no desire that's greater than the Constitution of this country. And the Constitution clearly dictated the dictate on the two-thirds gender rule.
But I think it is also extremely unfortunate if the CJ Maraga does not appreciate the dynamics that are in this country and also the challenges that are there in our communities.
In 2016, a similar attempt to have the bill passed flopped as it faced a quorum hitch in the National Assembly. The bill, then referred as the Chepkonga Bill, was sponsored by the then Justice and Legal Affairs Committee Chairman Samuel Chepkonga. In 2017, it was the Senate's turn to freeze the passage of the Gender Principle Bill that was introduced by the then-nominated Senator Judith Njeni. In 2012, the Attorney General sought a Supreme Court advisory opinion on whether the two-thirds gender principle was realizable immediately or progressive. The Apex Court's verdict agreed it could be done progressively in the Executive and Parliament, but gave a deadline of the 27th of August 2015 to establish a framework that would breathe life into the gender principle. This jolting the AG to form a working group in 2014 on achieving the gender parity principle. The working group returned a blueprint proposing amendments to various legislations to actualize the implementation of the gender principle. This included amendments to the Political Parties Act, Elections Act, Independent Electoral and Boundaries Commissions Act, the National Gender and Equality Commission Act, and the County Governments Act.
Actually supports the dissolution of Parliament. Fortunately, at least the Senate, we've achieved the two-thirds gender.
This constitution is progressive. You remember it's 10 years in place. And therefore, it would have been more better to give room for Parliament for progressive achievement.
This is a matter that we need to give ourselves time. We are growing. Our constitution is new.
But with the lapsing of the 27th of August 2015 deadline, High Court Judge John Mativo in 2017 ruled that Parliament had failed in their constitutional obligations to enact legislation on the gender principle and gave them 60 days within which to do so. The court further ordering that should Parliament fail to enact the legislation during this period, any person could petition the Chief Justice to advise the President to dissolve Parliament. And now, that reality is home. The Chief Justice has played the last card that the Constitution provides, setting the stage for a complicated national debate on how to take it from here. Sam Ogina, Citizen TV, Nairobi.